Have you or your trucking business ever been stiffed by a broker or freight forwarder that has gone broke or perhaps even had no intention to pay to begin with? While the situation may seem hopeless, with the right strategies you can still recoup a portion or even all the unpaid freight bill. Paul Taylor, managing partner of the Truckers Justice Center and a lawyer who has represented drivers and owner-operators for more than 25 years, has produced a handy guide to track down responsible parties and, potentially, payment. The first step is to understand who you're dealing with. Both a broker and forwarder must be registered with the Federal Motor Carrier Safety Administration. While they often operate in similar ways, their legal responsibilities differ. A broker serves as an intermediary between the shipper or receiver and the motor carrier hauling the load. A broker is not liable for loss or damage to the freight and thus most often does not carry cargo insurance. Freight forwarder, however, in its relationship with the shipper or receiver, is a carrier. Unlike a broker, a forwarder is responsible for loss or damage to the freight. In his relationship with a carrier, a freight forwarder has the status of a shipper. Think of a freight forwarder as a carrier without trucks or trailers. The significant legal distinction here is that a carrier hauling a load can look beyond the intermediary only to the shipper or receiver for payment. If the freight forwarder goes broke, the underlying motor carrier may not look to the freight forwarder's customer for payment. The answer to this question is, well, sometimes. If the broker was acting as an agent of the shipper or receiver, then you may recover payment from either a shipper or receiver. However, proving that agency relationship existed depends on certain facts. In the event of a lawsuit, courts will look at the degree to which the shipper delegated its shipping responsibilities to the broker. If the broker was effectively acting as the transportation department for the shipper, then there's a good chance of having a court find the shipper liable for the unpaid freight bill. Smart brokers draft their master hauling contracts with carriers to state that, quote, the carrier agrees to look only to the broker for payment of freight bills, or words to that effect. Under such a provision, a carrier may not look to the shipper or receiver for payment. The bill of lading, meanwhile, itself is a contract of transportation. If you are the carrier, make sure your business's name is shown as such on the bill of lading. It can establish your legal entitlement to payment from the shipper, unless you have agreed to look only to the broker for payment. Shippers usually use a short-form, single-page bill of lading that incorporates by reference terms of the long-form, uniform bill of lading, published by the National Motor Freight Traffic Association. Section 7 of the long form provides that when the non-recourse provision on the face of the short form version is signed, then the shipper is not liable for payment of the freight charge. Instead, the payment obligation is transferred to the receiver or some other responsible party. Smart shippers sign the non-recourse provision of the bill of lading when using brokers. Both brokers and freight forwarders must provide FMCSA with proof of insurance in the form of a surety bond or trust fund ensuring payment of freight bills up to $75,000. The name of the broker's or forwarder's bonding or trust fund company can be easily found within FMCSA's SAFER database. A claim against the bond or trust fund can be made by mail or in many cases electronically, with documentation that the load was delivered and that the freight bill remains unpaid. In the more spectacular cases of brokers' failure and fraud, if other carriers are similarly owed and claims exceed $75,000, the bond or trust fund company will often pay the money into a state court, discharging its payment obligations. The bond or trust fund company also files a complaint then that lists the claimants and says, essentially, we don't know who to pay. Claimants can then file with the court, which determines how the funds will be divided. Brokers often pledge their receivables to a bank as loan collateral. Other brokers sell their receivables to a factoring company that ends up owning the receivables. A bank or factoring company can acquire only the interest that the broker had. At least one federal appellate court has held that a bank to which a broker has pledged its receivables holds only lien on the broker's portion of the receivable. In other words, the bank or factoring company may well have been holding the money the broker owes you and you may be entitled to recover it. However, getting that payment is likely to require a civil court action against that bank or factoring company. Find more detailed discussion of these issues at this website address on Overdrive. Attorney Paul Taylor can be reached at 855-943-3518 or by visiting truckersjusticecenter.com.